Alex here to break it down to see where we stand on tort reform. Alex.
Well, Dylan, at least initially, the White House is putting the burden on the states, offering up about $25 million in federal grants to get the ideas flowing. Now, the government is on the lookout for better ways to improve doctor practices, to cut down on malpractice lawsuits, and ultimately cut down on the mistakes that lead to them. And here's Health and Human Services Secretary Kathleen Sebelius on it.
Lots of states have bits and pieces of the puzzle. There are states with screening panels. There are states that have review processes. There's some voluntary mediation efforts, and we think this is an opportunity to not only look at what has had a proven effect, lowering preventable errors, increasing patient safety, which is the #1 goal, improving communications, and lowering costs.
Now, overall, Dylan, the price tag for doctors is big. It is up to $200,000 a year for malpractice insurance for some doctors. But as Secretary Sebelius indicated, the really scary part here is the human cost, because the Institute of Medicine estimates that as many as 100,000 Americans die every year from medical mistakes.
Yeah.
Hello, world. Welcome to Malpractice Diaries, MD, the secrets they keep. I am Deirdre Dickson-Gilbert, your host. And with me today, we have Chip Wagger, a great guest, and we have a great show for you today. We will be talking about the inconvenient truth about tort reform. Let's welcome Chip Wagger. How are you today?
I'm doing well, Deirdre. How are you?
I'm wonderful. So we want to welcome all of our listeners for tuning into our show, where we hope that we can really uncover what's under the cover, be real, transparent, and true. So let's go ahead and let's get started here. Can you tell us, Chip, a little about who you are, how long you've been involved in your specialty, any books, training, and accomplishments?
I'll be glad to. Well, I'm a trial lawyer. We hear a lot these days about trial lawyers. Well, I am one, and I've been one for about 40 years. I went to law school at Tulane University and graduated there in 1979. I've been practicing law ever since. For the first 30 years, or about 2/3, 3/4 of my career, I did mainly defense work for the oil and gas industry, insurance industry, and so on and so forth. But gradually over the years, I got interested in other things, including medical malpractice. And so for the last decade or more, I've been pretty much concentrated in the field of medical malpractice. I practice here in Louisiana, southern Mississippi, and along the Gulf Coast, but the bulk of my cases are in Louisiana. I am licensed in Texas, however, and do quite a bit of litigation over there, although not malpractice. But I'm very familiar with many of my colleagues over there in Texas who struggle with representing injured patients in medical malpractice cases in Texas as well. So that's pretty much, in a nutshell, my story. I'm these days pretty much a medical malpractice lawyer, and I represent patients who've been injured or families of patients who've been killed by medical malpractice.
Okay, good. Can you go ahead and tell me a little bit for a second? You stated medical malpractice. For those of us that probably don't know what that is, can you briefly give me a description of medical malpractice?
I sure can. Medical malpractice is a form of personal injury law, but it's a very specialized field for a lot of reasons. But basically it involves many of the same principles. Negligence on the part of the defendant has to be shown, that the negligence caused an injury or death, and the nature and extent of the injuries, or death, but mainly in injury cases, how much of the injuries or what injuries were related to the malpractice and what are not. Obviously, in medical malpractice, many of the victims were sick or injured to begin with, or they wouldn't be seeing a doctor or going to a hospital. So those injuries and that kind of thing are not compensable. Medical malpractice negligence, though, is really where things get different. You have to show in most jurisdictions that the healthcare provider, be it a doctor, nurse, hospital, whatever, breached what's known as the standard of care, which is not written down anywhere and is very hard to define. But you have to show what the standard of care was in the situation that existed. You have to show that the healthcare provider violated the standard of care and that caused injury or death to the patient. So in that sense, medical malpractice is quite different. As a practical matter, too, medical malpractice is a very expensive and risky type of personal injury. It's almost impossible to bring a medical malpractice case and to successfully assert a medical malpractice case without having expert testimony. And by that, I mean testimony by a medical doctor who's willing to testify in court that the defendant, who's also a doctor, committed malpractice. That's a very expensive and difficult proposition, as you can well imagine. Also, public attitudes about litigation, and I think we're going to get into that a little bit when we start talking about tort reform, favor the defense most of the time. Jurors are psychologically inclined to give the benefit of the doubt to a doctor and not so much to someone who's bringing a lawsuit, at least at the beginning. And that's something that as a trial lawyer I have to deal with every day. So that's, again, in shortened down, that's medical malpractice and how it's different from other kinds of personal injuries.
Okay, good. So let's talk about that for a second. Tell me, what is tort reform, and actually, when did this actually begin?
Well, tort reform is a term that means reform of the tort laws, and it started in the 1960s, although it was very obscure and not too many people knew anything about it, had never heard of it. Even by the 1970s and 80s, it was a very obscure concept. And what it means is insurance companies and usually large corporations, changing laws and procedures, usually that have been in place for decades, usually centuries even, in the case of Louisiana and Texas, laws and procedures that date back to the 1800s or earlier, and changing it to their advantage so that it results in less often is there a damage award, or the damage awards are reduced in size. So to my way of thinking, and to a lot of people, tort reform is a kind of rigging of the game by large corporations and particularly insurance companies. And in the case of medical malpractice, we're often talking about hospitals and medical associations who hire lobbyists to change laws that have been in effect for many, many years in their favor, and that's what they call tort reform.
Okay, well, so it's rigging of the system. Wow. Okay.
It is, and we can get into that in more detail, but it's definitely changing the rules to benefit themselves.
Wow. So it's changing the rules to benefit themselves. So let's talk about that. We're going to talk about that in a few minutes. So tell me, what is the fallacy of blaming lawsuits for healthcare costs? Because I know that this is one of the things that they say is responsible for tort reform or medical malpractice, or in their cases, frivolous lawsuits.
Well, the basic fallacy is, for the most part, it's not true.
Okay.
Or if it is true, the rise in cost is so minuscule compared to other causes that it's virtually not true. In each case where you see this argument made that lawsuits are responsible for raising the cost of car insurance or medical care in our field and so forth, when it sounds good, you might think when you first hear it, well, yeah, it stands to reason. If hospitals are getting hammered with all these big verdicts, of course they're going to have to raise their prices to pay for it or to buy insurance and so forth. The truth is, medical malpractice and liability awards in the medical field make up well under 2% of the costs of healthcare. Less than 2%. The real costs of rising healthcare involve a lot of different things, and the lawsuits are not among them. And it's the same with car insurance and so forth. When you dig down deeper, you find that the real causes are things having nothing to do with litigation.
Okay. And again, I guess that's their way of rigging the system.
Well, it is. And it's rigging the system and also deflecting blame from themselves. When you have CEOs of nonprofit hospitals making $5, $6, $8, $10 million annual salaries, it's kind of embarrassing when you're raising prices and, crying about the high cost of healthcare. So, let's find some other reason to distract people, from what we're doing,
Right.
The truth is, they are profit driven, and these executives that are calling the shots and hiring the lobbyists are most of them making multi-million-dollar salaries.
Okay. So, and I'm going to ask you a question as it relates to the healthcare costs. The hospitals themselves, are they actually nonprofits, for-profits?
Well, of course, you have different kinds. In Texas and Louisiana, for example, you have both nonprofit and for-profit hospitals. Ones that are, university-based, Baylor University, for example, or University of Texas Medical Center in Houston, or Louisiana State University Hospital in New Orleans and Louisiana and so forth. These are nonprofit hospitals. Having said that, in other words, they have the 501 tax designation. They're not taxed. Having said that, however, the administration and executives of these nonprofits do real well.
Definitely. I've seen it. So let's get into
for-profit hospitals. Of course, they're in, they make no bones about it. They're in it to make money, and so whatever they do, is designed ultimately to make the hospital profitable and to make money for the investors.
Okay, so I'm assuming when we say self-insured hospitals, is there a difference between the nonprofit and for-profit?
There can be. Most governmentally backed ones, maybe self-insured in the sense that the state government is going to pay any judgments or settlements on their behalf.
Oh, okay.
There are some private hospitals that have done the math and decided that it's more profitable for them to be self-insured rather than pay an insurance company premiums, that they can handle it better themselves. So, it varies from hospital to hospital.
Okay, so let's get into this one, because this is where I know that you and I have talked about this quite a bit. The fallacy of frivolous lawsuits. And actually, where did this term come from?
Well, frivolous lawsuits is a, what shall I say, a trigger word or phrase that is used to stir up hatred against the enemy, which is us, the trial lawyers. Frivolous lawsuit, well, by definition, is a lawsuit that has no merit, that is meritless. You would think, listening to the propaganda from the medical industry or the, insurance industry and so forth, that the courts are just snowed with frivolous lawsuits that should never be filed and that are meritless. That's debatable. I don't think it's true. And I'll tell you a couple of reasons why. First of all, most personal injury litigation, this includes medical malpractice, but virtually all personal injury litigation, the plaintiff's attorneys work on a contingency fee. Mm-hmm. If the case is meritless, the chances are they're not going to recover a thing. If they don't recover anything for their clients, they get nothing. So most plaintiff's attorneys don't like to handle meritless, frivolous lawsuits. It's a deterrent to it because you get nothing from it. Moreover, in the case of medical malpractice, you remember I was saying a while ago how expensive it is. Well, when you're hiring doctors as experts and having to take depositions and so forth, it's not unusual in a medical malpractice case to have 40, 50, 60, up. I've even invested more than $100,000 in one or two of my lawsuits because I had to do it. It had to be done to prove our case with experts and so forth. Not only if you lose that case do you get nothing, but you know, as an attorney, you've thrown away, you know, a lot of money. So we try never to take a frivolous case. We wouldn't file a frivolous case. There's no economic benefit to doing so. So it's kind of a propaganda piece by the other side to make you think that there's tons of worthless, meritless cases out there. But that's really nonsensical and doesn't make sense and isn't really true.
And I would think so. I mean, when you say the word frivolous, that simply means it really doesn't have any merit or it didn't really matter. But looking at the cases that we have seen over the last 10 years and the kind of cases that I know that you cover, I wouldn't consider any of those things as being frivolous, you know, and especially in the mind of some patients. I do understand that sometimes there are issues though, because family members doesn't understand why some cases are taken and then some cases are not taken. And you know, most of the time you all will tell everybody, you know, you have a great case. But again, I believe, as you say, it costs money up front that you all have to pay in contingency. And I don't think that, like you said, that a person would actually dish out that type of money on a frivolous lawsuit, knowing that in the end you may get nothing. So
I agree. I think sometimes also people confuse the term trivial with frivolous. Frivolous is without merit, as you said. Trivial is another matter. You know, going to court to file a lawsuit over minor injuries, you know, the old whiplash injury or, you know, these kind of things. Now, you know, reasonable minds can differ as to whether that's trivial or not. If it happens to you, it might not be that trivial.
Right.
There are damage claims that are worth, you know, in the lower end of the spectrum, you know. You know, are there a lot of those lawsuits? There may be. Most of these smaller cases, though, get settled before a lawsuit's filed or shortly after one is filed. In Louisiana, for example, we have a very short statute of limitations, only 1 year. So someone who has an automobile accident, if they don't settle their claim within a year, and they may be undergoing treatment still a year later, they can lose their case. I mean, they don't have a case. So sometimes these lawsuits are filed to, you know, preserve your rights, but the plaintiff doesn't intend to really litigate these things. So, you know, that adds to the number of smaller lawsuits. But that was something that the insurance company wanted, short time limits. It's an example of tort reform, a very short 1 year time limit. And it kind of backfires because it tends to encourage more litigation to preserve your rights.
Okay, because I know in Texas it's 2 years.
2 years, yeah.
2 years in Texas. Okay, so let's talk about the frivolous lawsuit because they talked about McDonald's hot coffee. And this particular movie or documentary actually gave rise to the attacks on frivolous lawsuits in the United States. Was this what you would consider frivolous? And if so, why not?
That movie was a brilliant piece of PR by carefully omitting a lot of pertinent facts. I'm just going to mention a few of them in a second.
Okay.
But it was very successful in stirring up people's perceptions that, juries were giving away money, jackpot awards. We've got to do something about this. So the truth is that the plaintiff in that case was a woman by the name of Stella Liebeck, and she was 79 years old when this happened. It was in Albuquerque, New Mexico. And her grandson had driven her to a McDonald's. This was in 1992. So she was in a parked car when the coffee spilled, something they made a lot out of. Okay, Ms. Liebeck acknowledged that it was her fault for spilling the coffee. What she took issue with was that the coffee was ridiculously hot. It was 180 degrees. And 190 degrees. And that's only 20 degrees under boiling, okay? And it caused third-degree burns of her genitals and her legs and required extensive surgery. McDonald's knew that was unsafe. They'd had something like 700 reports of people burning themselves on their coffee before this happened. And they admitted that the coffee was a hazard with these high temperatures, but they continued to do it. So when Ms. Liebeck presented her claim, all she wanted was them to pay them her medical bills and so forth, which they refused. They made an offer of $800 to her. She ended up, of course, with a multi-million-dollar award because the jury didn't see it that way, and felt that McDonald's, was negligent in making the coffee that hot. So she eventually settled the case, however, for $600,000. And you know what? McDonald's stopped making coffee that hot.
Wow.
There's another thing people don't often think about, how trial lawyers act as a check and a balance in our society. And things change because when you get an award like that against a company like McDonald's, as I say, this is in a language that they understand, and they don't want to have it happen again, so they do something. 700 people complaining didn't do anything, but a $2 million hit did.
Absolutely. And so basically, because I see here, when I was reading something, it was stating that the plaintiff actually was willing to accept like $20,000 to settle her case prior to trial. I'm assuming she didn't even know, as most of us don't know, how medical malpractice lawsuits work.
Well, that's right. It's a shock to a lot of people, for example, to find out that there are caps on damages in medical malpractice in Texas, Louisiana, Mississippi, Gulf Coast states. Yeah, most people don't know a lot about medical malpractice. Now, having said that, her case was a personal injury case. It wasn't a medical malpractice case, but it affects medical malpractice because it encourages the belief that we need tort reform to stop this craziness, when this is a single instance, a single thing, that is manipulated in a way to make it seem outrageous when it really wasn't.
So that's why I have a question with that. So since you're saying that was not medical malpractice per se, right?
No.
However, they used that as a means to, for their, I guess, when they were showing all of their commercials, this is what they were using as a basis on medical malpractice caps and all of the other things that they were saying frivolous. How did that get into play if this was not even medical related per se, or medical malpractice per se? How did it get entangled?
Yeah, that's a good question because it wasn't a medical malpractice case, but what it did do is it stirs up hatred against trial lawyers and lawsuits, and it makes it seem falsely like we're in some sort of a crisis. We're under attack. We've got to do something to defend ourselves before the whole thing comes tumbling down, where there really isn't a crisis, and people really aren't under attack. One of the things I would like to say this evening that I think is really important for your viewers to really understand. Tort reform really means taking away your rights, okay? That's what it means. Taking away your right to a trial by jury by putting caps on it in advance, regardless of what the evidence is or how badly you're injured or how agonizing the death may have been. They're taking away your right to trial by jury. They're taking away your right to your access to the courts because they're putting things in the way like medical review panels or affidavit systems or all kinds of devices that in no other personal injury case do you have to go through, but you do in medical malpractice, you see. So taking away your rights if someone were to say, would you mind if I took your rights away? Would you mind giving up some of your rights? Most people would not want to give their rights up,
Right, absolutely.
No one wants to do that. So how do they do it? You were asking a moment ago, how does hot coffee or some of these other propaganda pieces, work into medical malpractice? And the answer is because they want to take your rights away, but they know that wouldn't be popular. They know that wouldn't pass. So what they do is they demonize the enemy, and that's us, the trial lawyers. We're the enemy. And we've got a lawsuit culture, and we've got a litigation culture, and we're gonna crash. And here's a perfect example of it: the old hot coffee story.
Right, right. So, and I'm just gonna go on to that question, which is, all trial lawyers are just greedy and like to sue. So that's the perception that I've gotten, along the way. And we've seen that a lot, and still, not as much as we used to because they're focused on something else right now. But basically, the system is still the same. All trial lawyers are just greedy and like to sue. Why is that a problem with trial lawyers? It's okay for the defense, right, to protect their client. So why is it so difficult? Or why is it that they don't want trial lawyers? How did you all get to be, I'm going to see the pick of the litter?
The bad guys.
Pretty much, right.
The guys with the black hats.
Absolutely.
Well, trial lawyers, to be, in the generic sense, include defense lawyers in white shoe law firms, making hundreds of thousands of dollars or even $1 million salaries defending insurance companies and hospitals and big corporations. They're all trial lawyers too. I mean, if they go to trial, they're trial lawyers too. So you're right, but that's not what they mean when they call out the trial lawyers. They mean people like me, and the reason is because we're the ones that bring the lawsuit. We're the ones holding them to account. We're the ones that are bringing justice, and that means in many cases that they have to pay damages. So they don't like us, and they don't want that. And then they want to rig the game so that we're wiped out if possible. And so trial lawyers, yes, the word greedy is inevitably put in front of us, isn't it? Greedy trial lawyers. Well, let me say this as a trial lawyer. I love what I do. Mm-hmm. There are few satisfactions in life that I've ever had greater than helping someone whose life has been destroyed by medical malpractice, who's had a family member who died, sometimes long, lingering, agonizing deaths, or who are paralyzed, or who have brain damage, or who have lost a child, almost unspeakable tragedies, that life will never be the same again. And you can't turn back the clock, and you can't undo what has been done to them. But you can get a little justice for them. And you can get them compensation, because that's the only thing that our civil justice system recognizes, to attempt to give you some consolation for what you've lost forever, for the rest of your life. Most of my clients have suffered a permanent injury or death. They'll never be the same again. So it's immensely satisfying to be able to help someone in that situation. Trial lawyers are human beings, We love what we do. We get immense satisfaction out of it. Having said that, I've told you a couple of times now how expensive it is to do this and how time consuming. We did a little survey in our law firm, and the cases that go to trial, our law firm can spend between 750 and 1,000 hours of work on the case. We can invest $50, $60, $100,000 into these cases. Okay? It's a business. It's a business. If we couldn't make money, we couldn't do it for very long, because I'm not that wealthy, So it is a business, but so are hospitals, so are doctors, so are insurance companies, So the hypocrisy here is sort of breathtaking. They're not greedy, but we are. But this is the propaganda, and it's gone unanswered for a long time, and we're fixing to do something about that, aren't we, Deirdre?
We are. We're definitely going to do something about that. And so let's get into another question I want to ask you. Physicians, they talk about leaving the state. They talk about, the fact that having all these medical malpractice suits causes them to, pack up and go. We know that many leave and go practice in other states. But tell me, what is the real reason why they're leaving? Are they leaving because of medical malpractice, and that trial lawyers are suing them, and it's just too much?
No, that's a lie. We know it's a lie. I might as well just be straightforward about it.
We want to be truthful, right?
It is a bald-faced lie. If you would like to get into this in any depth, I'd recommend the Center for Justice and Democracy. It's just a treasure trove of statistics and so forth, but I'll summarize it really quickly. There have been surveys done of medical students and residents who are finishing their residency and about to go, become full-fledged doctors somewhere. And they asked them to list the top 10 things that, would influence where they practice. Would they practice in Florida? Would they practice in Texas, New York, California, Idaho, wherever? Guess what's not in that top 10? Lawsuits and liability. Is the litigation climate in Idaho very favorable or unfavorable? It doesn't occur to them. That's not one of the factors that they consider. They consider a lot of other things like climate, schools, cities that are interesting to live in, or countryside that they like, and so forth. That's just one of the myths that pervade this whole propaganda campaign. Truth is, there's no proof whatsoever that doctors move from one state to another because the litigation climate is worse in this state than that. But what is true is doctors with 12 and 15 medical malpractice cases against them often do run from state to hide and get away from what has happened, because their license is about to lose their license. So they go to another state, and practice there. That causes some movement.
And we're going to have to talk about that, because that happens quite a bit, where we've seen physicians with 10, 15, 20, some even 30 or even more lawsuits that have been filed against them. and they can go from state to state. But we do know that there is something called the National Practitioner Data Bank, right? And why don't they use it?
You would think that would, and that's indeed why it was formed in 1982 to,
Right.
keep track of these doctors. Of course, the other side of the coin is that the receiving hospital in, let's say, California, I'm thinking of one particular doctor who I brought 2 medical malpractice cases on, both for the absolute highest limits of recovery, both times. One case, he almost killed this woman. In another, he caused a gentleman to lose his leg all the way to the hip because he was a surgeon. He was incompetent. And he ended up in California. And the second lawsuit I filed, he had moved, and I actually took his deposition out in California. The problem is that there is a doctor shortage in this country. That's a fact. There's a lot of doctors retiring. There's a lot of burnout. You may have noticed you live in the Houston area.
Right.
If you go to, let's say, Texas Medical Center, MD Anderson, Baylor, whatever, think about how many doctors that you find there that are from were born in foreign countries. Where would we be without them? I mean, we don't have enough doctors is the truth. But that has nothing to do with malpractice. That has to do with, how expensive it is, how difficult it is, and the, burgeoning demand for doctors in this country. We do have a doctor shortage. So what happens is hospitals, let's say in rural areas, they'll pretty much take anyone they can get. You got an MD and you've got a license, we'll take you. It doesn't really matter how many lawsuits you've had against you. Of course, when you're a patient entering the hospital, they don't tell you, by the way, our general surgeon on call has 15 medical malpractice lawsuits and has paid millions in damages, but he's all we got. Want to come in?
And that's what I can't understand is,
the lack of transparency.
Absolutely.
Oh yeah. Everything's a secret.
We've seen a lot of cases because, one of the cases, and I went into the system and was looking and just reading, and they used to keep this on the data on their website, but it seems that they took it off. But I just remember one doctor stating that he loved to go in the backyard and sniff deep woods off. And I was saying, oh my God. And they continued to allow him to practice medicine. And I'm saying, so the person goes in the backyard and sniffs something and goes to have surgery. And it's like, we can't get anybody else to come to work. So let's go get him. He's okay. Maybe he'll be okay.
Better than nothing.
By the time he gets there, maybe he's going to be okay. So we really need to work on that piece of the puzzle as well, as we talk about that. And I want to talk about this huge public relations movement, because this is where we are right now. And I've been doing this for 10 years. You've been doing this longer than I have. I'm not an attorney, but been digging and trying to figure out where to go with this issue. We know that it's the 3rd leading cause of death in America. We've had some statistics to say like 1.5 million people die of medical error a year. That's a lot of people. But nobody actually knows anything about this at all. When we talk to people, they probably know in your state, if they hear 1 or 2 cases. In Texas, I hardly ever hear any cases of medical negligence. I see most of it on Facebook when somebody posts it, but we never really see these things. So what is it with this public relations movement that they have? What is it that they have that we need something? What do we need?
Well, they spew their false facts, their propaganda around the time the legislature goes, into session, and around the time, election time for legislators. This is what happened in Louisiana. Last year, we had governors and legislature were elected, and tort reform was way high up on the list of what the business community wanted to have done. We've already had rounds of tort reform in the 80s and 90s, but that wasn't good enough. So they beat the drums pretty hard. But after that, they have something we really don't, and that is lobbyists. Lobbyists who spend time carving out new privileges and thinking up new loopholes for their clients, the hospital, in our case, the hospitals, doctors, the medical profession, so on and so forth. Who are the lobbyists that lobby for the victims? There's only one.
Yes.
Us.
Absolutely.
The trial lawyers. We have lobbyists at the Louisiana legislature. We have lobbyists at the Texas legislature. We're one group against hundreds of lobbyists that are hired by insurance companies, hospitals, medical profession, and so on and so forth. We're the lone voice there, which is another reason why they hate us. If they could just get rid of us, they would have the field completely to themselves. But what we need to do, and what we lack here, is a education campaign, a public education campaign to bring the facts, such as the one you mentioned, third leading cause of death. For an American today, what is the chance that you'll die of medical malpractice? What is the chance that your death will be due to medical malpractice? It's 1 in 10. It's 1 in 10. The cost to the taxpayer. Who's going to pay for this paraplegic when we've got caps on awards and so on? Who's going to pay for the life care for this brain damaged baby now for the rest of its life? Who should pay for it? The wrongdoer or the taxpayer? Because right now, it's being deflected off to the taxpayer. Social Security, disability benefits, Medicare, Medicaid.
Right.
Yeah, the taxpayer's paying for it, not the hospital or the doctor that did this. Is that right? We need to get that kind of thing across to people. You're paying for it. You're subsidizing them. You're protecting them. This is a privileged class, and you're not privileged.
Right, because I'm real excited because you are right that the Louisiana trial lawyers are the only ones who have a lobbyist that are working on behalf of the patient, and I want to say thank you for heading that up, because we need that. And I do know that you all were at one time you almost got a bill, and what happened in the midst of the stream where the bill just went to sleep, or
they ran out the clock on us.
Wow.
We had a very unusual situation. The medical malpractice cap in Louisiana is $500,000. That's it. No matter, and it caps. It's a hard cap. It caps everything. It caps everything except medical expenses, loss of income, and so forth. I won't go into great depth on it, but we'll just, for simplicity's sake, $500,000. There was a compromise bill to raise the medical malpractice cap to $750,000. Now, Louisiana, just to give you an idea, Louisiana's medical malpractice cap was passed in 1975.
Oh.
Gerald Ford was president of the United States back then. Are you old enough to remember that, Deirdre? I mean, it's a long time ago. No cost of living, no consumer price index. Today, $500,000 in 1975 would be worth over $2 million today. Okay, but it's $500,000. It's shrunk. the purchasing power of $500,000 in 1975 is about $194,000 today. Okay?
And
So
in Texas, you have what? You have 250.
250.
Right?
Now it's a softer cap. It doesn't cap. It doesn't cap income loss and so forth, and you don't have some other odious provisions that we have over here. But that's a very low cap. So we had this bill going. We had just about reached a compromise that we could pass, but we had a budget crisis in 2018, and the governor basically terminated the legislature ahead of time so that a special session could be called to deal with this budget crisis. Actually, I think there were 2 or 3 special sessions called in a row after that to deal with the budget crisis. Mm-hmm. So we ran out of time. And then the last year, 2019, Louisiana has alternating fiscal and general sessions. So in 2019, only tax and other fiscal measures could be brought up in the regular session. So there we are. And then 2020, we've had a round of tort reform, and we have a legislature now that's extremely dominated by the business lobby here. Mm-hmm. So that's what happened here. But I'm happy to say, and maybe we'll get a few minutes to discuss it, the NMMAA Louisiana chapter is about to launch a public education campaign in the near future to bring out some of the facts and truths and dispel some of the myths that have permeated this whole discussion up until now.
And we're already, I know that I have been contacted by a couple of other attorneys to create more chapters such as yours to do the same thing, trying to get a lobbyist. And I think that what we need to probably focus on, as you said, not sure how great it will be if we were in the courts or in the House, White House, or where we need to go with this. But if we had a lobbyist in every state, somebody just like you did, approach the organization and willing to create these chapters so that we can have this voice across the states to do it. Would that be something that you think would help, or yes, no?
Well, yes. I mean, we can educate, and we're going to start doing that, and I'll come back to that in a second. But in the end, you need political action in the legislatures.
Okay.
Most medical, not all, but most medical malpractice laws that limit patient rights are state laws. And so it's in the state legislatures and in the state courts that the battle needs to be fought. There are some federal laws, obviously affecting veterans, the VA hospitals, and other acts that, for instance, EMTALA, the Emergency Room Act, that you can't turn someone away without caring for them. And so there are some limited areas that the federal government is, but most of the time we're talking about state government, state acts, state legislatures, and governors. So that's where the laws the lobbyists have to go, and we have to pass laws. Now we have the trial lawyers, the Louisiana Association for Justice in this state. We have lobbyists, and they're very good at it. Even though they're outnumbered and outgunned a lot of times, they're very good, particularly when it comes down to lobbying the legislature. But what they don't have is a good foundation to work from. You get this propaganda campaign that's been going on for years, creating this false impression of a crisis, that we're under attack, that we've got to do something, that the cost of health care is going up because of these greedy trial lawyers, and so on and so forth. We've had that for years and years and years, and we've had no pushback. And that's what our chapter of the NMMAA is going to do, is we're going to push back, and we're going to tell the truth, and we're going to get the truth out there so that the trial lawyer lobbyist, the LAJ in this case, in this state, has something to work with. These legislators don't have, just a free pass to take away more rights from patients and victims than they already have, and hopefully encourage rolling back some of these draconian laws that have, hurt patients in Louisiana. And I think we can do that in Texas, and I think we can do that around the country.
And we have, we have some great attorneys that are coming on board. And I believe that I'll just have to do that introduction, because I want to thank you for, first of all, because for several times I wanted to stop, and just slow it down and forget about it. But you would always, for some reason, have me in the back thoughts and say, no, you can't stop. We're going somewhere. We're going somewhere. It may take us a little time to get there, but we're going somewhere. We're coming almost to the end of this episode, and it is so much to medical malpractice, and it's so much to what you have to say. And I will definitely bring you back. But tell me something, because, again, we've been going at this for a very long time. We want to know, and I think you briefly stated that we're going to have a movement of some sort where we can be at the top of the headlines. And I just want you to know that this organization is here to help to bring that to fruition. What do you want to tell the people before we go for today? What do you want to tell them? What is important for them to know at the end of this?
I'd like to say, come and help us. We've fought a lonely battle, the trial lawyers, and they hate us, the greedy trial lawyers.
Right.
They've demonized us. They've taken your rights away. They have had the field to themselves, and we're going to keep fighting. The organization here, the NMMAA Louisiana chapter, is going to launch in the near future a public education campaign. The most effective thing is for people like you, Deirdre, and others who've been victims of medical malpractice to get out in front on this and help us trial lawyers get the message across. This can happen to you.
Yes,
this
it can
very well happen to you. I know your story, Deirdre. You would never have thought, bringing your child up, you would have never thought that could happen to you.
Absolutely.
And it does. It doesn't interest people until it does, and then it's too late. You have to get out there. The victims who are not lawyers need to raise your voices and to be heard, and to take the opportunities when you can to be heard and to be seen. And that's the great thing about this organization, the NMMAA. It's not a lawyer organization. It's not the Louisiana Trial Lawyers. It's an organization that is made up predominantly of victims of medical malpractice.
Yes,
and this organization and you, Deirdre, have provided a channel and a voice for these people to speak up and cry out to change this injustice that has been visited on us for way too long, and to ask for change. And together, I think with the trial lawyers, we can get somewhere. We can do something and help people who have not yet been injured by medical malpractice, but will be. And when their turn comes, they will not be as out in the cold as you and so many others who belong to this organization now. We can help other people.
Absolutely, and that's what we want to do. So we're running out of time, and I just want to say once again, thank you, Chip, for being here today. And I just said world for today episode of Malpractice Diaries MD, the secrets that they keep. I want to thank you for listening, and thank you again, Chip, for coming on. And join us every Monday at 7 p.m. for another great episode. Make sure that you subscribe to our YouTube channel, Facebook, Twitter, and Instagram, so that you will never miss our show. We're looking forward to next week's show, because guess what? I'll be talking about my daughter's story so that we can go through and realize that this can happen to you. So signing off, and I see you soon. Thank you for joining us, Chip.
You're welcome. Thank you for having me.
You're welcome. Have a great day.